So Stanley, why don't we start off with you, and perhaps you could talk a little bit about the scope of the problem.
Okay, let me just introduce myself. I'm Stanley Foodman. I'm the CEO of Foodman & Associates. We're a full-service accounting firm specializing in litigation support, international and domestic tax, and we're ranked among the top 25 accounting firms in South Florida. In addition to providing expert witness testimony and forensic accounting services, I represent clients in international and domestic tax compliance matters, corporate taxation, estate, trust tax, and high net worth individuals in the U.S., the Caribbean, Central and South America, and Europe. And I've had really the honor of being able to work with these two gentlemen on multiple cases. The Foreign Account Tax Compliance Act was enacted as a means of combating overseas tax evasion in 2010. The federal government right now estimates that it has an estimated tax gap of about $345 billion annually, partly as a result of non-compliant international reporting by U.S. taxpayers. Under FATCA, foreign financial institutions will be required, among other things, to provide information about all accounts owned or controlled by U.S. taxpayers. If a covered financial institution tries to evade the requirement of the new law, it risks losing its correspondent U.S. banking relationships, among other consequences. This has been called by some folks the neutron bomb of international tax and banking. And there's a lot of resistance being brought to the U.S. government about it. This law constitutes a sweeping change in how banks and the general public do business abroad. It makes banks gatekeepers and arms effectively of the IRS. Likewise, brokers, attorneys, and accountants involved with foreign transactions will have their own responsibilities under the law. U.S. taxpayers who may have willfully been out of compliance for years and U.S. taxpayers who may have no idea they're not in compliance will also be at risk of federal penalties and possible prosecution as a result of FATCA. Last month, IRS Commissioner Doug Shulman announced that FATCA implementation would be phased in due to all of the complaints and requests for slowdown in its implementation. This allows more time for anxious banks to implement systems needed to comply with the law, and it became good news for taxpayers who would like to comply. Under the phase-in, by June 30th, 2013, foreign financial institutions must enter into individual agreements with the IRS. This is outside of any other treaty obligations that exist. In order to be identified as participating institutions in this program. In 2014, reporting will begin and withholding will be fully phased in by 2015. While these dates may seem far away, they're not. And especially not for clients who need time to get their affairs in order, and for banks who must change the way they do business and effectively report their on their customers, or turn those same customers away. Right now, I can tell you that I've seen banks asking customers to leave in Panama and other places which were traditional havens. So it is something that's being implemented even before the phase-in by certain banks. It's important to understand the law and what's required of your clients and, of course, your profession. The other thing that I want to mention, which I'd be remiss if I didn't mention, is the Offshore Voluntary Disclosure Initiative that was about to expire on August 31st and has been extended to September 9th due to the effects of Hurricane Irene. When the Offshore Voluntary Disclosure Program was conceived of, FATCA had already been passed, and yet the IRS chose to have a different set of dates for voluntary disclosure than they have for implementation of FATCA. So it's not something that's very balanced, to say the least. In February, the IRS announced the program and its August expiration date. It's now announced a September 9th expiration date. And by doing what they've done and not allowing the two laws to be coterminous effectively, an estimated 2 million people, 2 million U.S. taxpayers will not have the same opportunity to bring themselves into compliance with U.S. international reporting obligations and avoid possible prosecution. And with that, I'm going to turn it over to my colleagues.